Sir, Zoom user, you're gonna to have a shirt on for court. I don't know if you can hear me.
Good afternoon, everyone. Are we ready to start?
Yes, Your Honor.
Okay. All right. Good afternoon, ladies and gentlemen. I am Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is the State Expedited Accusations calendar, wherein cases have been assigned to this calendar for individuals who have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will be the defendant's initial appearance before state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I want to let everyone know that the SAP state all-purpose reset date is what date?
It's going to be June 8th.
I see it in the chat now. June 8th will be the SAP reset date. I want to remind the defendants on this calendar that you do have certain constitutional rights. The first being that you have a right to counsel and representation at this stage for your bond hearing, that you also have the right to remain silent. Anything that you state about the facts and the circumstances or the occurrences of this case can and will be used against you. The state is here and they're listening, so listen to your attorneys. I also want to remind everyone this entire proceeding is being recorded as well as live streamed on YouTube. So again, govern yourselves accordingly. Who do we have first, Deputy?
Position 19, Ms. Toke.
Okay. Position 19 is 23 CR 003309F. Madeline Toke, you're charged at one count of simple assault, family violence. The offense date is April 29, 2023. Pretrial? First, okay. State?
Yes, Your Honor. Good afternoon. How are you?
Good afternoon.
Good. This incident occurred April 29th, 2023 at 642 McGruder Street. And this is where officers arrived and watched camera footage of the defendant yelling in Miss Emily Gainey's face. Miss Gainey told officers that the defendant was holding a knife at her side while she was yelling in her face. Miss Gainey also told officers that she was fearful that the defendant may harm her in that moment. The defendant and Miss Gainey, they lived together, and Miss Gainey called the police earlier because she believed that the defendant was stealing her belongings. And so Miss Gainey had pulled put up cameras in their residence, and the defendant would take the cameras down. And this incident started because Miss Gainey was putting back up the camera that the defendant took down. Our office was able to speak to Miss Gainey today. She said that they were roommates and that she still lives at the residence, but she hasn't been staying there because she's fearful of being around the defendant. And she also confirmed the events listed in the warrant, Your Honor. For these reasons, the state's recommendation is a $5,000 surety bond, 1 day anger awareness, no further contact with Miss Emily Gainey, to stay away from the 642 McGruder Street, as well as no alcohol, drugs, or weapons while out on bond, and a one-time police escort so the defendant can retrieve her belongings. And if Miss Gainey is on the Zoom call, I would like to sound for her.
Okay, Ms. Gainey. Is Ms. Gainey on the Zoom call? All right. Keep
Your Honor,
proceeding.
I'm sorry, Lance
Yeah.
Patrick on behalf of the defendant.
Oh, okay. Hello, Mr. Patrick. Good to see you.
You as well, Judge. So, I'm sorry, I didn't mean to interrupt the state.
Is the state complete?
Yes, nothing further from the state.
Okay, thank you. Go ahead.
Your Honor, first of all, the defense would point out that camera footage caught the argument, but camera footage did not catch the knife, according to the state's recitation of facts. So based on that, there may or may not actually have been a crime committed here. Therefore, the state would recommend, old habits die hard. Therefore, the defense would recommend that a signature bond through the jail be issued. The one anger management session, Your Honor, frankly, we think the rest of the conditions are a bit unwarranted, Your Honor. The rest of the story, what Ms. Gaines obviously did not tell the state, is this seems to have been precipitated after Ms. Tulk sought a temporary protective order from Ms. Gaines. So I don't think that was approved. I think there was a paperwork error. I think Ms. Tulk filled the paperwork out incorrectly. However, that is what precipitated this. Ms. Tulk is currently residing with her mother in Flowery Branch. So the one-time return to retrieve belongings, we don't object to that, of course, with a police escort to prevent Ms. Gaines from making any other allegations in this case. But Your Honor, the state would point out, as far as the the defense would point out again to the IALA conditions. Ms. Tulk is a student at Oglethorpe University, finishing the last couple of hours of her degree. She works full-time also at Knauf, K-N-A-U-F, Insulation. She's an engineer, just started that a couple of weeks ago. She's a Georgia native. Her entire family resides here in Flowery Branch in the metro area. You heard from pretrial, this is a first arrest. She has never had any negative interaction with law enforcement. Based on that, the defense would request a signature bond through the jail at this time. Thank you, Judge.
All right.
Your Honor, just quickly, the report stated that the officer spoke with Ms. Gainey, and she advised that while the argument was ensuing, that the defendant had the knife in her hand. And furthermore, when we spoke to Ms. Gainey, she did confirm the events that were listed in the warrant, and she said that she is fearful of the defendant, and that's why the state's recommendations were stated as is.
And Your Honor, just to respond briefly, the defense would stipulate that Ms. Gaines probably said that. However, I haven't seen the police report. All I've seen is the accusation. However, based on the recitation of facts, they saw the argument on the surveillance camera footage that Ms. Gainey put up, and she told them of the facts that would give rise to an offense in this case. Clearly, this is not the forum for a general demurrer. However, they saw the argument. She told them of the knife.
Okay, I am, as you know, both council know, I'm not going to belabor the facts or argue the facts at this point, just for bond purposes, so I'm ready to rule. Because we could go back and forth on that. And I know you all will argue that and do motions at the proper time. I'm going to go ahead and order the $5,000 signature bond through the jail. I'm going to order no drugs, alcohol, or weapons while on bond. I will allow that one-time police escort to return to the property to retrieve any personal belongings that Ms. Talk may have there. I'm going to order a stay away from 642 McRuder Street. And I'm going to order no further contact with the victim, Emily Gainey. That's
Thank
all
you.
I'll order at this time.
Thank you, Judge.
All right, thank you.
Fine. Position 2, Ms. Bynum.
This is 23 CR 003300C, Jessica Bynum, charged at 1 count of criminal trespass. The offense date, May 24th, 2023, pretrial.
15 total. 2013, she had a couple of probation violations. 2012, phase 2 appear.
All right, state.
Yes, Your Honor, this happened May 23rd of 2023. Officers were called out to 2273 Country Club Drive at about 10:56 in the morning. The officer spoke with Eunice Bailey, who stated that she called police to report that her niece, the defendant, had been returning after being told not to. The defendant had been advised by Miss Bailey and by law enforcement not to return to the property on previous instances, and on this date was found on the back patio of Miss Bailey's home asleep. The defendant was then arrested. We had a chance to speak with Miss Eunice Bailey, and she stated that the defendant used to live with her about 3 years ago, but refused to pay rent, so she stopped allowing her to stay there. She stated the defendant keeps returning back to the property, and that at times the defendant can get violent, including a time where the defendant busted out her windows on two different occasions. Miss Bailey does not want the defendant to return to her property and wants no contact. I would like to sound for Miss Bailey. I will state the defendant has 2 probation violations in 2013 and FTA in 2012. There's a $1,500 surety bond already set on this case. We ask that it remain as set. Stay away from 2273 Country Club Drive Southwest. No further contact with Eunice Bailey. No alcohol, drugs, or weapons. That's all for the state.
He said there's already a $2,000 surety bond.
$1,500.
I mean,
I'd like it
1,500.
to remain in place, and Miss Bailey is here on the line, Your Honor.
All right, Ms. Bailey. Can you unmute yourself? I can't hear you. Can't hear you. See the red microphone? When you press that to unmute yourself, we can't hear you. All right, Ms. Bailey.
Yes,
All right. Do you wish to address the court today?
I would like to.
All right, I'm going to just allow you to briefly do that. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes,
All right, you can put your hand down. Are you in fear of Ms. Bynum?
well, no, I don't fear her because she's not going to do anything to me. It's just the people that live with me that try to keep her from coming in. They're in fear of
Okay, so you have some other
her. Yeah, her son,
tenants or family members? Family members?
all them family members, yeah.
Okay, okay. All right, and you don't want any more contact with her as well, is that correct?
None, because
Okay.
she upsets me every time I see her.
Okay. All right, I don't have any more questions. Anything else, Deputy Falk?
No, I think Miss Bailey has made her feelings about no contact very clear, and we would just ask that the defendant respect her wishes.
All right, PD Wills?
Thank you, Judge. My client is 58 years old. She was previously living with Ms. Bailey, as it was stated. However, she does plan to move to Union City. She is originally from Georgia, and she states that she will be relocating and living with her cousin, Mr. Odell James. She is currently unemployed, but does receive disability for her back. And she has been disabled for the past 10 years, and she does qualify to receive our services. She is currently unable to make her $1,500 surety bond. So we would request that her bond be at least reduced if you are not inclined to grant a signature on bond. She does have a high school diploma from George High. She received or had 2 years education from Atlanta Technical College. And she stated that she returned to Miss Bailey's residence to obtain medication. That was the purpose for her being there. However, she has no objection to not returning. She understands that Miss Bailey does not want her to return there. She has no objection to no further contact. Your Honor, I would ask again, my client is unable to make bonds, so any bond will be unattainable for her. And she does have plans to move, and she does have a known address.
But I'm assuming she doesn't have any personal items at this location. Is that correct?
That I'm not sure of. I neglected to ask that question of Ms. Bynum. Ms. Bynum, do you need a law enforcement escort?
Yes.
So I would also request that, Your Honor.
Okay. I'm going to leave the bond at $1,500 surety. I'm going to order a stay away from 2273 Country Club Drive. I'm going to order no further contact with the victim, Eunice Bailey, or no further contact with any residents at this location. One-time law enforcement escort to return to the property to retrieve any personal items. No drugs, alcohol, weapons, or guns while on bond. And that will be it for this case.
Your Honor, if I may, I just wanted to confirm, does Miss Bynum have any items at Miss Bailey's home? Because she left that home 3 years ago. So
Right.
I don't think there's any need to have a one-time law enforcement escort to bring her back onto the property when she hasn't legally lived there for, according to Ms. Bailey, 3 years now.
Maybe Ms. Wills, can you ask her, does she have any items there that she needs to retrieve?
Yes, Ms. Bynum, do you have any items that you need to, that are still at that residence?
It's my clothes and I still have some of my medicine there.
So we have 3-year-old medicine, I
No,
suspect.
it's not 3-year-old.
I'm sorry?
You know I've been back. You know I've been back.
Okay, Ms. Bynum, without saying too much, anything you say can be used against you. Your Honor, in speaking with my client, she indicated that she had lived there more recently than 3 years ago. It was quite recent, and that's why she had returned to pick up medication that had been delivered there.
Okay. All right, I will allow a one-time law enforcement escort. And remember, Ms. Bynum, you're not to return there until you coordinate with law enforcement to escort you there, to meet you there. You should not be there by yourself, and you should not go there at all unless law enforcement is there with you. I don't want you to be rearrested again, because if you go there without law enforcement, you will be back in the Fulton County Jail, okay? All right. That should conclude this case.
I'm trying to see, I don't know what's going on.
Position 7, Ms. Grant.
Okay. This is 23 CR 003302E. LaShanya Grant, charged with 1 count of willful obstruction of a law enforcement officer, 2nd count, false report of a crime. Offense date, May 24th, 2023.
Third arrest, open burglary out of Clayton County
All right, state.
back in 2020.
Oh, okay.
Your Honor, this incident happened May 24th, 2023 at 3215 Cushman Circle. The defendant told police she was robbed while walking on Brownlee Road in Atlanta, and that the person who robbed her stole her keys, firearm, and dog. She stated that she followed the air tag back to Cushman Circle and did not know who the person who robbed her was. Officers went to that address on Cushman Circle and spoke with a gentleman named Brandon, who stated that he was involved in a past relationship with the defendant, and showed a text to the officers where he went to Decatur Street to meet with the defendant. Officers then re-interviewed the defendant, who admitted that she had a friend pick her up from Decatur and drive her to Atlanta to make a police report, and that the incident, she still alleged the incident occurred, but she stated it did not occur in Atlanta, but rather in DeKalb County. Based on all of this, as well as her changing narrative around what occurred and identifying this person named Brandon as the potential person, she stated when she talked to the officer, she said that Brandon left her home around 1 a.m. and stated that he was showed them a video of him leaving with the same description of clothing she had given previously for the robber. And initially it said that the person had a ski mask on, and then stated she wasn't sure if it was Brandon who robbed her. It was basically a mess. The officers, however, were able to ascertain that she was definitely lying about where she was when all of this happened, placed her under arrest and charged her with giving false report of a crime and obstruction of an officer. The state's recommendation is a $3,000 signature bond through pretrial services. No alcohol, drugs, or weapons. That's all for the state.
What's the breakdown?
1,500 per charge, Your Honor.
Okay. All
Your
right.
I would have no objection to a signature on bond. I would just like to note for the record that my client does deny the allegations as alleged, but we have no objection to a signature on bond.
Okay. All right, I will order the $3,000 signature bond through pretrial.
That'll be per judge, open case.
Oh, I see. I forgot the open case. Do you know, PD Wills, about the living conditions for Ms. Grant?
She provided an address for me. She confirmed the address that was listed on her booking report and is not at the incident location.
All right, and she's how old?
She is 28.
Okay. I will order the $3,000 signature bond through the jail. I'm going to order that would be $1,500 on each charge. I'm going to order a stay away from 3215 Cushman Circle. No further contact with the victim. I think is it Brandon? I didn't get a last name.
There is no last name.
I do not have a last name on the police report either, Your Honor.
All right. And no drugs, alcohol, weapons, or guns while on bond. And I think that'll be it for this case.
Thank you, Judge.
All right.
Position 1, Mr. Aldridge.
This is 23 CR 003299E. Cedric Aldridge, charged with 1 count of simple battery. Pretrial.
11 total. Last arrest was 2016, disorderly conduct. On probation for 3 counts of robbery out of Decatur County. 2012, they gave him 2 years to serve and 15 years probation for that. 08, reckless conduct, simple battery, theft by taking conviction. That's it.
Okay. State.
Yes, Your Honor. This incident happened on May 24th, 2023 at around 8:30 p.m. at 6490 Gray Fox Way in Riverdale, Georgia. The defendant grabbed Miss Tara Kelly by her shirt, told her to get out of a car, and then was, after reporting that to police, the defendant was placed under arrest. Unfortunately, that's all the information we have on this case at this time. The state is recommending a $2,000 surety bond, no further contact with Tara Kelly, no alcohol, drugs, or weapons. That's based in large part of because of the defendant's history, which includes that robbery conviction.
All right, PD Wells.
Your Honor, Mr. Aldridge is 41 years old. He is a Georgia native. He is currently employed by Tyler Perry Studios as a groundsman, and he will not qualify for our services after today's date. He does have 3 children, one of which is a minor under the age of 18. My client states that he and Miss Kelly have been in a relationship for the past 10 years, that they had an argument over his infidelity. Miss Kelly did become upset. He wanted to leave. She did not want him to leave. He attempted to unbuckle her seatbelt. However, her shirt was caught in the buckle. He did not intend to harm Miss Kelly. There was no harm done. The allegations are that he grabbed her shirt. That is not the situation. The situation was escalating, and my client wished to leave, or wished for Miss Kelly to leave the vehicle. He did call a friend to pick him up so that he could leave to de-escalate the situation. Miss Kelly stated that she was going to, quote, hit him where it hurt, and she made a police report. She called the police. I would like the court to just take in consideration what's actually being alleged. The longevity of the relationship between my client and Miss Kelly. He does not have, other than this robbery that's from 2016, he does not have any violent convictions. He has no convictions that involve himself or Miss Kelly. And so we would ask for a signature on bond. And if Your Honor is not so inclined, we would ask for a $500 surety bond. And we would also ask for no further violent contact between my client and Miss Kelly.
Your Honor, 2 things. One, the state was remiss in leaving out a stay away from 6490 Gray Fox Way if that is not the defendant's residence. 2, we would like to sound for Miss Kelly. And lastly, due to the fact that I have not had contact and the state has not had contact with Miss Kelly, I don't know if the public defender's office has had contact with Miss Kelly, then we would ask that no further contact order be in place until Miss Kelly can respond as to whether she wishes to have contact at this point or not.
Okay. Is it Tara Kelly? Or Tara Kelly? On the Zoom call? All right, I have heard the arguments from both counsel. I'm going to order a $2,000 surety bond. I'm going to order a stay away from 6490 Gray Fox Way. I'm going to order no further contact with the victim, Tara Kelly. Then I order no drugs, alcohol, weapons, or guns while on bond. And I believe that'll be it. Anything else, counsel?
No, Your Honor, nothing from the state.
All right.
Nothing from the defense. If Your Honor is not inclined to reduce the bond at all, my client just recently was employed by Tyler Perry Studios, so he does not have a lot of money on hand.
I think 2,000 is reasonable under the circumstances and given the allegations that I'm hearing.
Yes, Judge. Thank you.
Thank you.
Position 3, Mr. Callaway.
No, man. Your Honor.
This is 23 CR 003301Y. Daryl Callaway, charged at 1 count of criminal trespass, 2nd count of theft by shoplifting. Pre-trial.
He got a total of 114.
I'm sorry.
114. Last arrest was 2023 February, crossing state county guard lines with drugs and all that trespass, possession of marijuana. Shoplifting from this year, conviction, 2020 shoplifting no low. 2019, he was arrested twice for shoplifting no low. That's it.
All right, Deputy Falk.
Yes, Your Honor. I mean, admittedly, it's not the worst record I've heard of my 20 years of being a prosecutor, but it's certainly up there in the top 10. This defendant had on May 24th of 2023, went to the 5 Cleveland Avenue address of the 24-hour food mart, went in, took a number of items, food and beverages, and then left with those items. When they spoke to the store clerk stated that he had been issued formal trespassing orders on November 10th, November 23rd, November 24th, December 11th, and December 20th. This incident happened, again, as I said, May 24th, and the defendant, the officers provided the officer with, the clerk provided the officer with a cell phone video of the defendant that showed him taking an energy drink, food, and water, and then leaving the store without paying. And at that point, he was placed under arrest. He admitted he was inside about 1 or 2 hours ago when the officers arrested him, but he advised he had taken the items from a different store, but would not tell the officers which store. So based on all of this, Your Honor, the state does have some BHET concerns. There's clearly a history here of the 100 plus convictions. I think largely they were criminal trespass and theft by shoplifting. The only reason this case wasn't sent up to the DA's office was because he had pled guilty in municipal court and was not represented by counsel on most of his previous theft by shoplifting convictions. He had about 3, but they were not represented by counsel. Then he had 2, one here, one in municipal court in 2023, and then here in 2019, which were represented by counsel. So we do have some serious concerns that there may be some other underlying issues here. The state's recommendation is going to be $1,000 surety bond on each case for a $2,000 surety bond. Stay away from the 24-hour food mart at 5 Cleveland Avenue Southwest, no alcohol, drugs, or weapons, and BHET.
All right, PD Wills.
Thank you, Judge. Mr. Calloway is 52 years old. He is a Georgia native. And in speaking with him, he was interested in speaking with our social service workers in our office. And so I will be asking that they visit him in jail. He states that he previously was employed by Apex Shipping and Receiving. However, he is no longer employed there. He does have a high school diploma from Walter F. George High School, and he received an associate's degree in business management. He also reports that he was honorably discharged from the Navy, and he served 3 years, and he does have a 7-year-old child. Mr. Calloway, and upon me speaking with him, I did review the prior criminal trespass warnings and arrests that he had. He does understand that he cannot go back there. He states that he will not go back there. He does deny the allegations as alleged. He absolutely is unable to make any sort of bond at this time. We would also object to a BHET at this juncture in the case. I would ask for a signature on bond, and if your honor is not so inclined, I would ask that you reduce the bond that's currently in place for Mr. Calloway.
And PD Wills, and I may be referring to the wrong thing. I thought a BHET was the social worker going out to do an evaluation.
Possibly. I'll put that in my email.
Okay, because the state, just to clarify, is requesting a BHET, not an MHET at this time. I will also put on the record for the court that he has currently a $3,500 surety bond, $2,500 on the criminal trespass, and $1,000 on the theft by shoplifting. So the state is recommending a downward departure from the bond that he's currently in on.
All right, and your state's recommendation is 2,000, 1,000 on each.
Yes, Your Honor.
Okay. Anything else, PD Wills?
No, Your Honor. I would just ask that if he is released before a social worker can't go out there, I guess that would also just be my reason too. If they're unable to speak with him, if he is able to make bond, I just would not like for him to be required to have a BHET. I just don't want to risk him violating his bond.
Well, usually we put it in the order, so it would be required. If those are services that he's going to need in order to help him to successfully stay on bond and report back. I don't know if he has any other challenges. Is he residentially challenged? I'm not sure.
He provided 2 addresses, a mailing address and a residential address for me. But when I asked about housing, he did indicate that he would be interested in speaking with a social worker.
All right, I'm going to order the $2,000 surety bond, $1,000 on each charge. Going to order stay away from 5 Cleveland Avenue, which is the 24-hour food mart. No drugs, alcohol, weapons, or guns while on bond. And I guess that's it, just to stay away. There was no identified victims in the case, correct?
No, Your Honor, just a store clerk who told him to leave. So I don't think that we need a no further contact as long as he stays away from the store.
All right, so you understand, Mr. Calloway, if you get out on bond, you're not to go back to that store anywhere near there, okay?
Excuse me, ma'am.
I don't know if your attorney's going to want you to ask this question. Does it relate to the bond conditions?
I really need a signature bond, ma'am. The item that was.
Sir, don't talk about the facts of the case, okay? Okay, only talk about your bond. If you have a question about your bond, ask about that. Don't get into the facts of your case.
Okay, as much as I can.
Okay,
On the wall at this location, it's a stone wall connected to the deck on sidewalk for the city.
Mr. Bynum, you're talking about the facts of your case.
Sitting on that wall with items with UPC codes that would tell the people that I hadn't stole any items from this store. I say, officer, if you check the UPC codes, or go in there and have them scan in those items, it'll say that the items is not from this store. I bought the items from what you call it that up the road from that store. I come down there and tell a woman hello.
I think you're getting too far into the
I
fact.
apologize.
This is not your
The
trial.
items been
This is just a bond hearing. I want to make sure that you're going to return to court and abide by the conditions of your bond. I'm close to ordering a BHET so that you can be seen and advised before you leave the jail. Behavioral health evaluation. So let me add that to the order, Ms. Champion, and I will stick to the $2,000 signature bond. I'm sorry, surety bond. It's $2,000 surety bond, 1,000 surety on each charge. Okay. All right. Next case.
I'm on a sidewalk thinking about how to do something for my kids with items from another convenience store being accused by stealing. I'm in my thinking pattern. I had just got released. Please help me help my children. Please.
Well, we have reduced your bond was, I think your bond, as the state pointed out, was 3,500, and we reduced
Please.
so that 10% give or take. So we have reduced it from 3,500 to 2,000.
I just left out of here 3 days ago. I was in my thought pattern on the stone wall to figure out what's my move.
I understand you need to be careful. You have a long, extensive history.
I'm trying to help my children and grandchildren.
I understand, but you've got 100, you have 114 encounters. You have 114 arrests.
Please.
I hope that
So
you
who's
keep.
next?
Your Honor, I would ask that courtroom 2 be muted. This case has been concluded before my client makes any further incriminating statements against his interest.
All right, deputies, we have to move on.
Position 5, Mr. George.
Okay. This is 23 CR 003277J, Charles George. We have one account of DUI, driving under the influence of alcohol, less safe, pre-trial.
54 total. Last arrest was May 6th out of the cab. It was probation. Got an open case in the cab for 2 counts of battery, disorderly conduct, shoplifting. On probation for ag assault, terroristic threats, possession of a knife or firearm during the commission out of the cab. See the ag assault, another terroristic threats. Okay. On parole for trafficking cocaine. 2022 failed to appear, 2018 and 19 probation. 2018 DUI suspended license, possession of cocaine conviction. 2017 DUI NOLO. That's it.
All right, state.
Your Honor, he also is a multi-state offender with cases out of Michigan and Ohio, as well as Florida. His Michigan and Ohio cases are relatively remote. His Florida cases go up to 2008 and were, I believe, 5 cycles. As far as his history here, he has actually 2 previous convictions for DUI in the last 10 years. There was one in 2017, and I believe that was out of, just look really quickly, I believe that is out of Bullitt County State Court that he was convicted on, and then another DUI from 2018 out of Cobb County Superior Court, where he was also convicted of possession of cocaine and given, it looks like, 3 years on probation on that case. So I just wanted to kind of fill in a little bit of the, kind of flesh out this out a little bit, so you know his pertinent history. I will say on this particular case, the defendant was observed at 788 West Marietta Street in Atlanta, Georgia. He was occupying an undrivable vehicle that was in the roadway. The defendant did admit to, there was damage to the defendant's vehicle, and I believe, yes, he admitted to hitting an unknown object. This was around 10 p.m. on May 22nd. The state did NOD the hit and run, because we're not actually 100% sure what he hit. We did not find, no one has at this point reported damaged vehicles or damaged property, and so the state cannot proceed on the hit and run. However, we are proceeding on the DUI. The state's recommendation on this is going to be a $7,500 surety bond, no alcohol, drugs, or weapons, and absolutely no driving.
All right, PD Wills.
Thank you. Mr. George is 60 years old. He has been a resident of Georgia for the past 20 years. He reports that he is employed by Capital City Protection Services as a security, or works in their security department. He has been there for the past 1.5 years. He does have a high school diploma as well as an associate's in hotel and restaurant management. Mr. George does deny the allegations as alleged. He was recently in the hospital. His case was reset for the past 2 days. And he was hospitalized yesterday where he had to have a CTC scan. He states that he was injured during the course of a robbery. We are asking for a signature on bond, and if your honor is not so inclined, I would ask for a bond of $1,000.
All right, I'm going to, what did you tell me was his work? Did he work security or he doesn't work security anymore?
Yes, he has been employed by Capital City Protection Services for 1.5 years.
All right, I'm going to order $5,500 surety bond. I'm going to order a no drugs, alcohol, weapons, or guns while on bond. I'm going to order no driving unless he has a valid driver's license to the DDS, which I don't think that he has at this point. And I guess there was no stay away. So that's it. All I'm going to order at this time. $5,500 surety.
Thank you, Your Honor.
All right.
Your Honor, before you call your next case, I hate to interrupt. Krista Parker is position number 13 on today's calendar. Her husband this morning, if I could get a breakout room with her just for judicial economy, that way I don't see her in the courtroom and haven't.
I heard she
But
was medical from what I was told.
Oh,
Okay.
so she wasn't brought today. So she's going to be reset till tomorrow.
Yes, medical reset.
Okay, medical reset till tomorrow, Mr. Patrick.
Okay. All right.
Do you have any other questions? I guess you'll just have to call down to the jail to see.
And she's at Rice Street, I assume then.
Is she deputy?
Yes.
She is at Rice Street, yes.
All right. I appreciate it. Thank you so much.
But she's in medical, so.
All right. I will attempt to go see her.
Okay. All right. Thank you.
Thank you. May that complete my business. May I be dismissed?
You may. Thank you.
Thank you, Judge.
Uh-huh.
Position 8.
All right. Who do we have next? Deputy?
Position 8.
8. Okay. This is 23 CR 003306C, Bradley Gutierrez, 1 count of stalking, pretrial.
13 total. Last arrest was in September, failure to appear. 2020 burglary, dead docket. And he had the 2022 fugitive from justice arrest. That's it.
All right, state.
Yes, Your Honor. So this incident occurred April 22nd, 2021. And this is where Miss Brooke, I'm sorry if I mispronounced the first name, Bradriah Nelson, that's spelled BADRIYAH. This is where Miss Nelson reported to officers that her ex-boyfriend, the defendant, started to contact her again after the TPO against him had expired. It expired April 16th, 2021, and this report was April 22nd, 2021. The defendant, Ms. Nelson, explained that the defendant did not take their breakup well, so he began threatening to harm her. He was showing up places without her consent, and the defendant continued to call and text her threatening messages, and he threatened to harm her family. The defendant even begged to fly Ms. Nelson to California, where he claimed to live now. Also, the defendant set up a fake interview so that Ms. Nelson could show up. And the defendant admitted to doing this via text message to Ms. Nelson. Our office was able to speak to Ms. Nelson today, and she did confirm that they're no longer in a relationship. She stated that she has had multiple TPOs placed on the defendant, but he keeps violating them. Ms. Nelson told our office that currently she has a TPO that is set to expire August the 23rd of 2024. And the case number on that is 2020 CV 338892. She also let our office know that she's had over 20 police reports of the defendant stalking and harassing her and threatening to kill her and her family, Your Honor. She informed us that she's had to move 5 times away from the defendant, and the defendant continues to find out where she lives. And she let us know that she feels as though the defendant is not going to listen to the court orders when he, if and when he is released, Your Honor. For these reasons, well, the defendant already had a bond set at $5,000 surety, and so the state wants to keep that $5,000 surety bond. Again, no further contact with Ms. Nelson, and to stay away from 111 Oakley Industrial Boulevard, as well as no alcohol, drugs, or weapons while out on bond. And if Ms. Nelson is on the Zoom call, I'd like to sound for her.
I am.
Excuse me, Judge, you're muted.
I'm sorry, Miss Nelson, you're on the call. Miss Nelson.
Yes, ma'am.
All right. Do you wish to address the court today?
Yes, ma'am.
If you do, I would have to be able to see you. All right, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. Are you in fear of Mr. Gutierrez?
Yes.
All right, and I assume you don't want any contact. You have a TPO right now that is set to expire in August.
Yes, ma'am.
Okay. All right. Anything else you'd like to say to the court?
I'm wondering, is there any way that I can get assistance with him cyber stalking me? Because I've been placed under surveillance multiple times and moved multiple times within the last few years.
All right. Well, our order, this bond order, will say that he is not to contact you via any social media, email, phone, in any regards through any third persons or himself. So it would include that, but that may also be something you'll need to address with the solicitor's office as well. And I think you've been in touch with your victim witness advocate. Is that correct?
Yes.
And they will talk to the prosecutors about that. And they can give you a little bit more advice, but I will include all of the conditions on this bond order, that he have no direct or indirect contact with you, as well as no email or social media or anything of that nature, to see if that will assist you temporarily, but the state can help you a little farther, okay?
Okay.
All right. PD Wills?
Thank you, Judge. My client is 35 years old. He is not a resident of Georgia. And prior to his arrest, he was employed by First Elements Fuel as a site manager and lead engineer, where he had been employed there for 2 years. He does have a high school diploma as well as degrees in engineering and cryogenics. He was in the Marine Corps for 5 years. He does have an 8-year-old and a 6-month-old. This case is a little bit different. My client reports that he has been incarcerated for the past 12 months in Coweta County for charges that somewhat are related to the alleged victim in this case. The alleged victim is my client's former fiance. He did contact her. There was a prior protective order that was in place that had expired, and he did reach out to her to speak with her about it was near the anniversary of the death of their child together. As a condition of the bond that he was placed under in Coweta County, he does have a permanent ban from contacting the alleged victim in this case. My client understands that he cannot contact her, has no desire to contact her, will be moving out of the state, resuming his residency. He already has it arranged where his probation will be transferred to a state of residence. He has to be, he must report weekly to probation, phone probation, and then monthly after a period of time. So he does not plan or intend to abscond. This charge or this incident occurred back in 2021, Your Honor. I would ask that the court take that into consideration, especially considering the fact that my client has been lingering in jail for a year. And this case could have been handled during the course of that time and concluded. And the state had more than enough time to bring this case and accuse this case. For all of those reasons, I would ask for a signature on bond so that my client can be released. He can go home. Again, he does intend to report to all future court dates. He did hire a private attorney for his other court who did attend or can attend for him in absentia. And if Your Honor is not inclined to grant the signature on bond, I would ask for no more than $1,000 signature bond. Again, my client has been incarcerated. He has no money.
Well, he's been incarcerated in Coweta County on the other charge. Here, I only have him in Fulton County for 1 day.
I understand, Your Honor, but this incident occurred back in 2021. This case could have been resolved years ago. That's not my client's fault.
Your Honor, although the case was back in 2001, we heard from our victim who stated that she's had to still move 5 times. She feels that the defendant is not going to obey the temporary protection orders against him to not contact her. And so regardless of when the case was brought, the state's recommendation is a $5,000 surety bond.
And I would argue again, Your Honor, this case happened in 2021. There are no other charges since that time. It's been over 2 years. So the victim, the alleged victim might have fear of my client. I don't know anything about that. All I know is that the charges being brought before the court today are over 2 years old, and they could have been resolved during this time that he was incarcerated.
Your Honor, we're still well in the statutes of limitations and when we can accuse a case for a misdemeanor charge. So.
All right, I'm going to order the $5,000 surety bond. I'm going to order again a stay away from 111 Oakley Industrial Boulevard or any residence that the victim may be residing at. I'm going to order no further contact with the victim, Ms. Nelson. And I'm going to again order that defendant should have no contact directly or indirectly with the victim, victim's family, and her professional, personal, close associates by phone, mail, email, page, or any writing, sign, note, or message. He must also stay 200 yards away from her. But I understand he also has a permanent protective order in place until August. However, this order will stay in place while he's on bond. No drugs, alcohol, weapons, or guns while on bond.
And I do want it noted for the record, I'm sorry, Your Honor.
Go ahead.
That my client, as part of his sentence, he does have a ban from Georgia, so he must immediately leave the state. He was actually worried that he would be in violation of that condition of his probation. So I'm sorry that I failed to mention that, but I do feel that that is another reason why my client has an incentive to leave the state, not have any further contact, so that he can avoid any further legal issues.
I thought the ban was just from Coweta County, so the ban was from the whole state of Georgia. Well, if he gets out on bond, he just needs to leave immediately. But I'm not going to change my ruling at this time.
And Your Honor, not to put too fine a point on it, but as long as I've been a prosecutor, that legally cannot happen. So Coweta may have other problems because you can ban from someone from everyone with the exception of one county in the state of Georgia. So they usually have to choose a county because constitutionally and legally you can't
Right to
ban
live
from someone
somewhere.
from an entire state.
Yeah, they have to have a right to live somewhere.
Yeah, it might be an invalid order, but that is his understanding of the order. So I'm not sure what happened in Coweta.
All right, I will stick by my ruling. All right, next.
Everyone, position 9, Mr. Jenkins.
This is 23 CR 003303Y. Aaron Jenkins, charged at 1 count of disorderly conduct. Pretrial.
16 total. Last arrest was 2018, domestic abuse battery out of Louisiana. 2018, well, okay, yeah, that's that. 2018, possession of a controlled substance conviction. 2016, theft. 2015, marijuana conviction, misdemeanor. 2015, simple battery DV, and a 2013 ag assault criminal trespass. That's it.
Okay, state.
Yes, Your Honor, my apologies. It took me a little bit of time to get to that unmute button. So this happened March 15th. Oh, excuse me, March 8th, 2023, over 8100 Roberts Drive in Sandy Springs. That's the location of the Dunwoody Springs Elementary School. Officers met with Elise Williams, who was visibly shaken up. She said she and a Sandy Springs officer were actually talking about what took place. Miss Williams was dropping off her children and was served by a court processor. And while getting served, the defendant was seen getting out of the trunk of a car and walking across the front field of the school while cussing in front of the parents, teachers, and students, and headed directly for Miss Williams. Fearing for her safety, the school staff took Miss Williams from the car and went inside the school where he could not get into the school and get to her. And the court processor then had to hold him back while Miss Williams went safely inside. We attempted to contact Miss Williams. We were unable to reach her because quite frankly, the warrant doesn't give a phone number for us to reach out to Miss Williams. And we did try to locate a good phone number for her, but could not. But the state has some real serious concerns about this one. I have not recently heard of someone climbing out of a trunk to go after a person, but I feel like this was a dangerous situation for Miss Williams. The fact that multiple people had to intervene, and that included school staff as well as the process server who at the time was serving her, definitely gives the state some concern for Miss Williams' safety. I do not believe there is currently a bond on this case. I believe the court, the magistrate court gave at this time a no bond recommendation. And I'm just checking that, Your Honor, real quick to make sure that that is correct. Yes. But based on the defendant's history that includes arrests for, as you heard from pretrial, aggravated assault, he also has, it looks like, a history out of, and they may have said that already, a history out of Alabama that included an aggravated assault charge in 2013, a fugitive charge in 2015, as well as a, let's see, just a moment, a domestic abuse battery in 2018, where he was sentenced to 2 years. The state does have concern for our victim's safety and is asking for a $7,500 surety bond, stay away from Elise Williams, no alcohol, drugs, or weapons, as well as a stay away order from the Dunwoody Springs Elementary School at 8100 Roberts Drive in Sandy Springs. That's all for the state. And we would like to sound for Miss Elise Williams in case she is here.
All right, Ms. Elise Williams, are you on the Zoom call? Elise Williams. All right, go ahead, PD Wills.
Thank you, Judge. I would like to bring some context back or to this case. My client and Miss Williams they share children together. They had a custody agreement out of the state of Louisiana, which Miss Williams willfully violated when she brought the children and relocated from Louisiana to Georgia. My client had, prior to that time, seen his children, who are 5 and 6, every single day of their life before she willfully was in contempt of a court order. My client, so it was mentioned in the facts that she had been served. She was being served by my client. So as a result of her being found or being in contempt of the court order for their custody agreement. My client and Ms. Williams did recently go back to court in regard to that contempt. I don't know if perhaps Ms. Williams was fearful because she know that she was willfully violating a court order. Maybe that's why she was scared that day. My client was gleeful because he finally had caught up with Miss Williams, if that were his children were. That is all. He had to hire a private investigator to have Miss Williams served. So he has gone through great lengths to ascertain the whereabouts of his children and be an active father in his children's life. That is all he wanted. He was unaware of this warrant. Again, this incident happened back in March. He states that had he known about the warrant, he would have relinquished himself to authorities. He actually drove 8 hours from Louisiana to Georgia to attend the pre-K graduation of one of his children, where he was arrested, unfortunately. And so he wasn't even able to view the ceremony. Again, Your Honor, this case is a disorderly conduct. I think that $7,500 is far way too much. And then given just the facts of the case and what's really going on, I would ask for a signature on bond, Your Honor. And if Your Honor is not so inclined, I would ask for a $500 surety bond. My client does not intend to abscond. He came to the state of Georgia with his mother to attend the graduation. He is employed as a chef at Creole House Oyster Bar, where he's been employed for the past 3 years. In addition to the children he shares with Miss Williams, he also has an 11-month-old child. The state did note some charges, but again, Your Honor, this is a disorderly conduct. I would just ask for, again, a signature on bond or a $500 surety bond.
And
So
Your
where
Honor,
does Mr. Jenkins officially live? Does he live in Louisiana? Or does he live in Georgia?
He lives in Louisiana. He drove here for the sole purpose of attending his child's pre-K graduation.
All right, Deputy Falk.
just briefly, Your Honor, if there's any reason Miss Williams is afraid, it's because of that conviction for domestic abuse battery, where he just concluded that case in 2021 out of Louisiana after being convicted in 2020. Additionally, there's a reason why we use process servers to serve civil matters instead of the jumping out of the trunk method of service, and it's for this reason. Finally, there were multiple witnesses at the scene, including the process server, who had to hold back his own client while Miss Williams made her escape into the building. I would say I understand this is a disorderly conduct, but we just don't look at the charge, we look at the facts. Thank you, Your Honor.
And I would just ask again, I would object to this conjecture and speculation. We don't know why she's fearful. Also, again, my client has gone through great lengths to ascertain the whereabouts of his children that he loves very much, that he shares with Miss Williams. Mr. Jenkins, please just wait for the judge to give her ruling unless it's about your bond. I advise you not to say anything about the case. These are just allegations at this time. You'll have the opportunity to fight this charge at a later date.
All right, again, with the children and the other case, that's a civil matter. But I do agree with the state, this is not a way to obviously serve someone with a civil suit or anything regarding, I guess, custody or whatever else they have going on. I am concerned about his actions. I'm concerned about his history and that he is not a resident of Georgia. I guess because his kids are here, he will obviously be back if he is granted any visitation, but I am very concerned. And I know it is just disorderly conduct. The facts are somewhere in between there, but I do want to make sure that the victim is safe while and when Mr. Jenkins is on bond, So I'm going to order a $5,500 surety bond. I'm going to order that he stay away. And I mean stay away from the school at this point, at 8100 Roberts Drive. And no further contact with Elise Williams. I am a little apprehensive about visitation if it is granted. So I'm not going to go there. I'm not going to order an escort. I'm not going to get into that because that's a whole nother ball of wax and another case for a different court. But he is to have no further contact, stay 200 yards away from Miss Williams and all the other conditions that will be in the bond order. No drugs, alcohol, weapons, or guns while on bond. And I think that is it. Anything else, counsel?
Nothing from the state.
I would
All
just ask, Your Honor, if you could at least reduce the bond to perhaps $3,000. Again, if there were enough facts or evidence for simple assault or battery, that's what he would be charged with, but it is a disorderly conduct.
Well, it appears that from the allegations that the other persons probably prevented that from happening. From what I've heard and from the incident report of the warrant, other people intervened so that there wouldn't be a simple battery case, fortunately. But I am concerned about his conduct. It's a little over the top. 10% is not a lot of money. It seems to be working. And so I am going to stick to and stay with the $5,500 surety bond at this time.
Thank you, Judge.
All right,
Mr.
thank you.
Jenkins, you can give me a call after court unless you have a question about your bond specifically. I would advise you not to say anything to the court at this time. And Your Honor, position, I'm sorry, I don't know off the top of my head the position, but Miss Sarkeesian, she was at the Alpharetta jail. She was supposed to be one of Mr. Pulliam's clients. I'm not sure if they're on the call, but he does need a breakout room to speak with her if she is not at the Atlanta jail.
Deputy, do you have any information for me on that? She looks like she's position 16. Someone asked me for a breakout in the chat.
I don't have any information. We were told earlier that they would not be transporting her here, and that was the last thing we heard from her.
Huh, okay. So they're not on, it appears.
Well, Your Honor, I would say if I could ask of courtroom 2, we do need to ascertain why, because we want to prevent a Riverside issue. We are not there yet, but I want to make sure that
He's calling Alpharetta jail now. That we don't know the reason why they thought they have a transport driver, but he's calling Alpharetta jail now to see what's going on.
I appreciate it so much, courtroom 2.
Thank you. Yeah, thank you. All right, who do we have next?
Position number 10, Mr. Johnson.
Okay. This is 23 CR 003304B. Ronald Johnson, charged with 1 count of theft by taking, pre-trial.
29 total. 2019 terrorist threats, 2018 assault, battery, reckless operation, 2015 witness intimidation, 2014 failure to appear, 2013 assault and battery conviction.
Okay. State.
Was this history out of Fulton County, Mr. Howard?
No, I don't think so. Not the one I saw. Hold on.
Yeah, can
You got something different?
Yeah, and that's why I was asking before I go into a recitation of facts on this.
All
It
right, hold
was-
on, let me see who they put.
And we're talking about Ronald Johnson, yes?
Yes,
Okay,
let's see who they put in here.
But he said that is not his history.
Okay,
He said
Okay.
it's not his history. Okay.
all right, this what they gave me. All right, stay, you roll with yours.
yeah, I just have, I
You
mean.
know what, hold on,
Oh.
yeah, because this history say white male. And-
Okay.
All right, yeah, so this is the wrong one.
So I have that he's a multi-state offender, though. He had he has 2 cycles in South Carolina. One for use of a vehicle without permission, where he was convicted in 2000, a 2009 attempt and conspiracy to violate the provisions of a drug law. He has 3 cycles out of Stamford, Connecticut, he's a convicted felon out of Connecticut from 2015. He has a burglary conviction also in Connecticut as well. He has, let me see, it looks to be 5 cycles in Florida. We have a equipment, narcotic possession or use in 2005. A conviction for that, 2000. Pardon, Your Honor, I'm looking at the date of trying to find the date of conviction. Florida NCICs are notoriously difficult. Narcotic equipment possession and use conviction in 2004. And then he also has a history out of New Jersey. And so we are showing, but his last conviction in New Jersey was 1999. He has 3 cycles here in Georgia, conviction for theft by shoplifting in 2003, a conviction for theft by shoplifting, possession and use of drug-related objects, arrest in 2018, and then this theft by taking. So in this case, Your Honor, there was a package that was delivered to the address at 2200 Godby Road, that's Cranbrook Apartments in College Park. The victim, Mr. Terrell Garth, stated his package had been delivered to his front door and had been stolen. He stated that when he looked at his security cameras, he saw an older Black male wearing a dark colored jacket, light colored button-up shirt, white shoes, dark colored hat, glasses, dark pants, appear to take the item and put it on a green cart and walk away. Officers then looked at the footage and were able to identify that, in fact, the package was stolen. And while during an apartment check on May 23rd, the officers observed that same person wearing similar clothing, who was identified as the defendant. He was then identified, placed under arrest, and at that point, the officer spoke with him and told him that he observed him stealing the package on camera. The defendant offered to show officers where the package was located, and he stated that it was at 5303 Joan of Arc Place. The officers went to that location, and let's see, the person at that location said that a male had come to his house and advised him to hold the package for him. At that point, the defendant was placed under arrest for theft by taking. Inside the package were 3 football helmets that were signed that cost approximately $725 in total. They were NFL football helmets. The state's recommendation on this is going to be $1,000 surety bond. The defendant does have a lot of history from a lot of different places, so the state would ask PD Wills if there's any plan in place to assist him, or if he does need assistance from a social worker, because it looks like he has a kind of checkered history throughout multiple states and does not appear to have any ties to the community, which is one of the reasons why we're recommending a surety bond. That's all for the state.
All right, PD Wills.
Sorry, Your Honor. We also would like to sound for Mr. Garth, and we are going to ask for no further contact with him and to stay away from the apartments at 2800 Godby Place.
Is it 2800 Godby Place or Godby Road?
Excuse me, 2200 Godby Road, Cranbrook Apartments.
All right. And do we have Terrell Garth on the line? Terrell Garth. All right, go ahead, PD Wills.
Mr. Johnson is 58 years old. He did provide an address for me. He states that he has resided in the state of Georgia for the past 4 or 5 years and that he relocated here for work. He states that he is employed by New Horizon, where he is the director of public relations and also provides counseling services, and states that he has been employed by that company since the year 2006. That it's a nationwide company, that he does have his high school diploma. He does not have any children. He states that he does not have a relationship with the alleged victim in this case. He has no objection to staying away from the incident location, and has no objection to not having any further contact with Mr. Garth. I would request a signature on bond. Your Honor, my client does not, he has very limited income and resources. I'll be happy to speak with him again. He did not indicate that he needed any assistance. But depending on what the bond amount is, I don't think it would hurt for me to send out an email to our social service workers to have a conversation with Mr. Johnson. Many of the charges that were mentioned are more than a decade old, and my client does deny the allegations as alleged. If Your Honor is not inclined to give a signature on bond, I would ask for a bond of no more than $1,000.
Your Honor, and I was remiss, our victim advocate was able to get in touch with Mr. Garth, even though he is not here on the Zoom. He stated he has seen the defendant around the neighborhood a few times, but has never interacted with him. He does not know the defendant, and I'm not sure if this is going to help or hurt PD Wills, but he also stated he was able to retrieve his stolen belongings back from the defendant. That's all.
All right. I think the state has recommended $1,000 surety bond. Is that correct?
That is correct, Your Honor.
All right, I will order $1,000 surety bond. I'm going to order no drugs, alcohol, weapons, or guns while on bond. I'm going to order a stay away from the apartment complex, and I'm assuming the defendant does not reside there at the 2200 Godby Road, Cranberry Apartments. He does not reside in those apartments. Stay away from the whole complex, Mr. Johnson. And also no further contact with the victim, Terrell Garth. And that's all I'll order at this time.
Position number 11.
Right. 11 wanted a breakout. Is that still the case? I saw in the chat earlier, who requested a breakout?
I believe it was position 12 that a breakout was requested for.
Oh, okay, not 11. Okay. All right, this is 23 CR 003311F. Tava Kumar. Sorry if I'm mispronouncing your name. The charge is pointing or aiming a gun or pistol at another. The offense date is May 24th, 2023. Pre-trial.
Hold on real quick. Let me see something.
Okay.
All right. I got first arrest. And the booking sheet says he's homeless. That's it.
Okay. State.
Yes, Your Honor. So this incident occurred yesterday at the Circle K located at 3255 MLK Junior Drive. And this is where officers received a call from the Circle K gas station that an employee, the defendant, waved a handgun at another employee, Miss LaShonda Varn. Ms. Varn informed officers that the defendant had picked up the gun, which belonged to another coworker, Miss Sandoval. And as Ms. Vaughn was walking back to the cash register area, the defendant was waving the gun at her, laughing, thinking it was a joke. Ms. Sandoval, the owner, she witnessed this. She took her gun back and stated that the defendant thought that his actions were a joke. Ms. Vaughn did advise officers that she feared for her life. We were able to speak to Ms. Vaughn today, our office was, and she did let us know that her and the defendant are co-workers at the Circle K, and she stated that the defendant, he picked up the gun and he was waving the gun in her face with his hand on the trigger. She let us know that she was extremely afraid for her life and that the gun was loaded at the time he did that, and that he thought the entire situation was funny. For these reasons, the state's recommendation is a $50,000 surety bond, no further contact with Ms. Vaughn or Ms. Sandoval, and to stay away from that Circle K at 3255 MLK Junior Drive, as well as no alcohol, drugs, or weapons while out on bond. And if Ms. Vaughn is on the Zoom call, I'd like to sound for her.
All right, Ms. Vaughn. Ms. Vaughn. All right, and is it PD Pulliam?
That's correct, Your Honor. Attorney Donnie Pulliam for Mr. Kumar today, Your Honor.
Okay.
Mr. Kumar is 24 years old, Your Honor. He is not homeless. He actually stays at 1137 Powers Ferry Place in Marietta, Georgia. The common name for that apartment complex is Marietta Crossings, apartment 2427. He stays there with his brother, Sandosh. Mr. Kumar, again, he works for the Circle K gas station where he is a cashier. And so he's been working there not very long. He recently came from South Carolina. He does hold a bachelor's degree, Your Honor. He's originally born in India, but has lived in the States for a number of years now. We would ask that find that the $50,000 surety bond is extremely excessive, Your Honor. As the pretrial stated, Mr. Kumar has no prior criminal history whatsoever. And again, we also disagree with what the recitation of the facts that the state gave today, Your Honor. Again, the state will have their day to prove their case in court. This is not what we're here for. We're here to make sure that Mr. Kumar is able to come back into court to answer for his charges. And so we would request that you grant him a UJR bond. If you're not so inclined to do that, Your Honor, we would request a very reasonable surety bond.
All right, I am very concerned about the allegations, and I understand that the defendant works at the Circle K. I don't know if he still works there, or if they've decided anything about his employment there, but certainly these allegations are very serious as it relates to co-workers at that Circle K. I am going to order a $20,000 surety bond. And with that $20,000 surety bond, I'm going to order that he stay away from that Circle K at 3255 MLK Junior Drive. I don't want to put anyone else in danger at that location, and certainly want to make sure if the victim is still working there that these two victims will be safe. No further contact with these victims, LaShonda Vaughn or Miss Sandoval. No drugs, alcohol, weapons, or guns while on bond. If he still has a gun, he needs to surrender it to the sheriff's department. And I guess that'll be all that I'll order at this time. Anything else from council?
Nothing from the state.
Okay.
But they're from defense, Your Honor.
All right, thank you.
Position 14.
This is 23 CR 003296J. Mr. Patel charged at one count of cruelty to children in the 3rd degree, 2nd count of battery, family violence. Actually 2 counts of battery, family violence. Pre-trial.
Second arrest. He got an open trespass in state court. 22 CR 006 262J.
All right, state.
Yes, Your Honor. So this incident occurred May 23rd, 2023 at 3400 Hamilton Avenue. And this is where officers arrived and they spoke with Miss Patel. Her first name is spelled SHANIBEM. And she advised officers that her husband, the defendant, had slapped her in her face and then he kicked her in her shoulder, leaving red bruising. And Ms. Patel also advised that her father, his name is spelled DHANANJAY. His last name is spelled UPADHAYAY. That her father tried to intervene in the altercation, and then the defendant slapped Mrs. Patel's father on the hand, leaving red bruising. And so officers also spoke with Mrs. Patel's son, who told officers that he saw his parents arguing and that he saw his father, the defendant, slap his mother in the face. The defendant and Miss Patel have been living together, or have been together rather, since she was 12 years old. Our victim witness advocate was able to speak to Mrs. Patel today, and she let us know that they are married, they live together, and they have 2 children together. She also confirmed the events in the warrant. She stated that this is not the first time that the defendant has been violent towards her. She let us know that she has called the police on the defendant before, but no arrests were made. She also let us know that the defendant curses in front of the children. Your Honor, furthermore, the Ms. Patel confirmed that the defendant stated to her, if you call the police and I go to jail, I'm going to F you up. And so for these reasons, the state's recommendation is an $8,000 surety bond, $3,000 each for both of the batteries, and $2,000 for the cruelty to children. No further contact with Ms. Patel or her father. 1-day anger awareness course. A stay away order for the 3400 Hamilton Avenue address, a third-party escort for the children, and a one-time police escort so the defendant can retrieve his belongings. And if Mrs. Patel is on the Zoom call, I'd like the sound for her.
Ms. Patel? Ms. Patel? Don't think she's on. PD Pulliam?
Yes, thank you, Your Honor. This is Mr. Ashish Patel. He is 40 years old. His address is the 3400 Hamilton Avenue, Atlanta, Georgia. However, if the court is not inclined to allow him to return to his address, he does have a friend by the name of Andy Patel who stays in Stockbridge, where he has advised he can stay. Mr. Patel is originally from India, but now has a citizenship here in America. He currently is a business owner and owns a very successful store, has been doing that for over 12 years. He has 2 children, 7 and 2. And we would ask, Your Honor, that the court grant Mr. Patel a $1,000 surety bond. Again, these incidents have not yet been proven in court. We would also ask that Mr. Patel, that the 1-day anger management course is usually something that is established and kind of ordered once a conviction has been made. And again, Mr. Patel has not been convicted of anything at this point. And so we just ask for a $1,000 surety bond, Your Honor, in this case.
Okay. I'm going to, going to order the $8,000 surety bond, 2,000 on the cruelty, 3,000 on each of the battery charges. So that'll be $8,000 surety bond. I'm going to order a stay away from 3400 Hamilton Avenue. I'm going to order no further contact with his wife, Shannon Patel. If he needs to go back to get any personal items while he's on bond, he must have a police escort or law enforcement escort. And I think that is it. Anything else, counsel?
Yes, Your Honor. No further contact with Mrs. Patel's father, and I can spell his name again for you.
I think they'll have it. And no further contact with Miss, do you have that, Miss Champion?
Yes, ma'am, I do.
Okay, right.
And I just want to make sure we have the third party escort for the children.
I don't know that I want to go there and order that. Are they small children? How old are they? Do you know?
No.
They're 7 and 2, Your Honor.
If there's visitation allowed, then there should be a transfer by a third party so that he doesn't violate any bond conditions. So I'll order that. Anything else?
Nothing from the state.
All right, thank you.
Come on.
Can we do Mr. Brown, position number?
Let them know what we're gonna do.
Oh, I don't know his position number. He's the add-on one. We have Ms. Sarkees in the courtroom. We're gonna take her to another courtroom so she can be interviewed by Mr. Pulliam.
Oh,
So
okay.
let's do Mr. Brown because he's Ms. Wills' client and the rest are Mr. Pulliam's.
Okay, I think they had asked.
Yeah, to do them at the end, but I want to get Ms. Sarkeesian interviewed by
Gotcha.
Mr. Pulliam, because the majority of the cases left are Pulliam's cases.
That's
Okay,
correct.
All right?
all
So,
right.
Pulliam, I'm gonna give you a call.
Okay, thank you.
All right.
You all have it under control. Thank you very much.
This is Brown, add-on one.
Thank you. Are we recording on this?
Your Honor, we can record, but they can turn off the YouTube if that's
All
what
right.
you're requesting, but we would like it recorded for the record.